for giving me the opportunity to clarify an audio that has been going around interpreting what this person terms as the new law that has come into Zimbabwe. My name is Kennedy Masiye. I'm an advocate of the law in Zimbabwe, and I'm also an international human rights lawyer, and I'm based in Dallas, Texas. Yes, Zimbabwe enacted the New Marriages Act, and this law was gazetted, I think, sometime in 2019, and it became law, I would like to believe, in 2022. And basically, this new law came in to harmonize the marriages acts in Zimbabwe. As you know, before there were two types of marriages. There's the Chapter 511. Some know it as Chapter 37, the one that does not allow a polygamous marriage, too many wives or husbands. And there was also the Chapter 507, formerly known as the customary marriage. So I would like to just go straight to what this gentleman is saying about what this new law interprets. I think it's not accurate. It's actually highly misleading for someone to come up with an audio trying to explain or expect what this new law says, or what this law says. I'll just go straight to probably, in fact, let me try to probably just in brief tell you what this law changed, or what it now means. This new law raised the age of marriage to 18 years, and Section 3 of the Marriages Act, the new act, now prohibits any person under the age of 18 from entering into a marriage or unregistered customary law union or civil partnership. So it's now illegal for even people to marry children that are below 18 years, as this is now become a crime. The new law, there's a new section again, which is in line with Section 78, subsection 1 of the Constitution, which provides that every person who has attained the age of 18 years has the right to found a family. So any person above the age of 18 years now can, without consent from parents, just get married. Going down to issue of consent again, Section 4 of the Marriages Act provides that no marriage can be solemnized or entered into unless there's given consent. So this pretty much deals with forced marriages, where probably kids, women, daughters, girls are forced into marriage, or arranged marriages, so to say. I think this is not much prevalent in Zimbabwe, but we have had cases, a lot of cases in certain sectors, probably religious sectors, where we see certain religious leaders having many wives, including young underage girls in a marriage. The Marriage Act also recognizes different marital regimes, and Section 5 of the Marriages Act sets out that the marriages, in fact, sets out the marital regimes recognized under our law in Zimbabwe, namely the civil marriage and the customary law marriage. And as I said, the civil marriage is a monogamous marriage. When you say that one wife, one woman. But when it comes to the customary marriages, on the other hand, that is a potentially polygamous, depending on the customary law of the people concerned. So that one, a man can have as many, wives as he wants. That has always been there. There's nothing new about that. So this can pretty much not be said to be a new thing, because that is what the customary law marriage, the customary marriages, has always been in Zimbabwe. So even though someone is married under the customary marriages, he can or she can or they can actually convert that marriage to become a civil marriage. When it becomes a civil marriage, then that one becomes a monogamous marriage, meaning to say that there cannot be any other marriage outside the civil marriage. And if one gets married while they're in a civil marriage, then it becomes a criminal offense in terms of the law. Section 44 of the Marriages Act, again, this new act, it's no longer new, but of the new act, further specifies, specifies more types of marriages, and puts in a new kind of marriage recognition, which is namely a qualified marriage, civil marriage, a qualified civil marriage, which is a union between a man and a woman contracted under Islamic rights, which can be registered subject to compliance of the provisions of the act. Section 5, subsection 5 of this act also describes all marriages in terms of the act are equal. However, the law does not explain how the marriages are considered equal. When one, requires, exclusively, having one wife, one woman and having consequences when the other one, which is politically, potentially polygamous, allows, a man probably to have many wives. So there's a bit of inequality there when it comes to the two regimes, especially when it comes to property distribution and so forth. But it does state that all marriages in terms of this act are equally, the same. The law also talks about rola and customary unions, and a ceremony for rola on its own is not recognized by the Marriage Act as a valid marriage. So in Shona Kungo, visa rola is not enough to say that you have been married. You've been married. You have to go further in terms of Section 17 of the Act, which requires unregistered customary law unions to be registered. So once you pay rola, you have to make a further step to then go to government offices and get your marriage registered within 3 months of the so-called ceremony. So you have to go. That's something new of which probably people need to know that for your marriage to be recognized, what visarora, you have to go further and have it registered, with the Register of Marriages within 3 months. So looking at the equal rights and obligations of probably these marriages, in terms of Section 6 of the Marriage Act, parties to any marriage have equal rights and obligations during the subsistence of the marriage and when the marriage is terminated. So it all goes down, which is debatable whether there are equal rights and obligations and so forth. But the law states that there are equal rights and so forth and so forth. And now going to the particular thrust, which probably many were interested in or are interested in, which are civil partnerships or probably my small house, as people would want to interpret. This law recognizes the so-called small houses, if there's any term like that, as potentially being civil partnerships. So the law says that a civil partnership is a relationship between a man and a woman who are both above the age of 18 and they have lived together without being legally married. So that, according to the law, is recognized, and that is a civil marriage. So civil partners must have a relationship as a couple living together on a genuine domestic basis. So if a man goes out and gets into a relationship with another woman, even though they are married under the the civil marriage or the customary marriage, this law recognizes that extra relationship as a civil partnership, so to interpret. But this law has not yet been interpreted by the courts, so this is just my own interpretation of what the law is saying. So a civil partnership is not a marriage. That's one thing. A civil partnership is not a marriage. However, in the event that the civil partnership is terminated, so here's the trick. Let me go back here. So the law now recognizes civil partnerships, aka small houses outside, just so that people can visualize. But this civil partnership is not recognized as a marriage. A civil partnership is not a marriage. However, in the event that this civil partnership, even though not a marriage, is terminated, the Matrimonial Causes Act, which governs the distribution of property upon divorce, shall apply with the necessary changes. So basically, the rights of the person within that civil partnership, even though not a marriage, has got the same rights as the rights of a person who is in a civil marriage or a customary marriage when it comes to the distribution of property. I hope that is clear. So in terms of Section 41 of the Marriages Act, the circumstances that are considered to decide whether a civil partnership exists includes the duration of the relationship, the nature and extent of their common residence, whether a sexual relationship existed, the degree of financial dependency or interdependency, and any arrangement for financial support between them. The ownership, the use of acquisition of their property, the degree of mutual commitment to the shared life, the care, support of children, the reputation, and the public aspects of their relationship. So that's what the law now looks at when they are looking at the issue of whether there existed a civil partnership when this partnership was terminated. So just to give an example, a man who is married and is in a civil partnership, in a civil relationship, a monogamous civil relationship, or a man who is married and is in a customary marriage, decides to go out with a woman or lives with a woman, not even live with a woman, but engages into a relationship with a woman, aka the small house. And if that relationship now fails outside the relationship of his current marriage, then issues regarding distribution, maintenance, alimony, properties, and so forth come into question, and they can be taken into consideration in terms of the Matrimonial Causes Act. So I think that's where probably this gentleman who was interpreting the law was trying to probably incite people or misinterpreting the law as it appears. But of course, this is a questionable issue when it comes to this piece of legislation, whether one who's not in a marriage can benefit from property distribution when that civil partnership ends. So, crucially, Section 41, subsection 5 of the Act appears to recognize that a civil partnership may exist when a person is legally married to someone else, including a monogamous civil marriage, as I just, highlighted. However, a court must interfere, with the rights the court must not interfere with the rights of a spouse when dividing the assets of civil partners when such partnership dissolves. You see, so for example, a man is married to a woman in terms of the Civil Act, and the man goes out and engages into a civil partnership or lives outside this marriage with a small house, so to say. If that partnership ends, that small house has got the right in terms of the matrimonial causes act to share properties with the men that he was with. But now what the law is saying is that in this distribution of property, when this relationship ends, the court will not interfere with the share of the woman who's in a proper civil marriage. They will only concentrate on the share of the man. But basically, it does not really matter, because if you're in a civil marriage and you're in a monogamous marriage, you all share properties. It doesn't matter whether they are going for the husband's share or her share, because when you're in a civil marriage, the presumption is that you all owe the properties together. So if a third party now comes in and acquires the share of the husband, it's just more or less the same as acquiring the property or interfering with the rights of the spouse within the civil marriage. So that's where the contention is when it comes to probably the interpretation of this section. But as I said, this is still a new law. It came into effect a couple of years. It's now probably a year plus now, and it has not yet been tested. So until the courts interpret these provisions in the manner that we have interpreted them, then we can have precedence on what the legislators were trying to, the law. The courts can interpret the law, probably giving the intentions of what the legislators were trying to put in. But in conclusion, I would caution people listening to the audio that is circulating, that is talking about a whole lot of things which I feel are basically misleading, not to listen to that, but to consult legal practitioners in Zimbabwe if they need any further clarifications on what this law basically says. But all in all, this is the general interpretation of what the new law entails, and what contentions are there, which I think to many the contention is around the civil partnerships and whether small houses can benefit from the estate of the husband when he is married in a civil marriage, which is monogamous. So thank you very much for taking your time to listen. I know this is a long one, but I hope it helps someone out there.